Hello everyone. Today we are going to discuss an important case law given by Supreme Court. In the case of Jamboo Bhandari versus MP State Industrial Development Corporation Limited and others, the Supreme Court has recently observed that the deposit of 20% of amount under Section 148 of the Negotiable Instruments Act as a condition to suspend the sentence is not an absolute rule. Now, before moving any further with the case law, let's discuss the legal provisions that have been involved in this case. Let's first discuss Section 138 of the Negotiable Instruments Act. So, this particular section deals with dishonour of cheque. So, when any person draws a cheque on an account maintained by such person with a banker to pay any amount of money to another person in discharge of any liability, and such cheque drawn is returned unpaid by the bank due to insufficiency of funds, or the amount of cheque drawn exceeds the amount that is arranged to be paid from that particular amount in accordance with an agreement with the bank, such person will be punishable with an imprisonment which may extend to 2 years, or with fine which may extend to twice the amount of the cheque, or with both. Section 148 of the NI Act is a second legal provision around which this case revolves. So let's have a look around what Section 148 Clause 1 states. So Section 148 Clause 1 states that in an appeal by the drawer against the order of conviction passed under Section 138 of the Negotiable Instruments Act, the appellate court may order the appellant to deposit a sum of money that shall be a minimum of 20% of the amount of fine or the compensation that has been awarded by the trial court. Now let's discuss what is a third legal provision that has been involved in this case. It is Section 389 of the Criminal Procedure Code. Now let's understand what this particular section has relevance to this case. Section 389 states that when an appeal by a convicted person is pending, the appellate court may, for reasons recorded in writing, order that the execution of the sentence or order appealed against be suspended. Let's have a look at the facts of the case. In this case, the accused was convicted under Section 138 of the Negotiable Instruments Act. This matter went in appeal before the trial court. The trial court, relying upon Section 148 of the Negotiable Instruments Act, granted relief under Section 389 of the Criminal Procedure Code. But this relief was subject to a condition that the appellant needs to deposit a sum of money that is 20% of the amount of compensation. This particular order was confirmed by the High Court of Madhya Pradesh. The High Court was also of the view that relief under Section 389 of CrPC can only be granted by directing the accused to pay a minimum of 20% of the amount of compensation or fine. While deciding the case, the Supreme Court noted that when an appellate court considers prayer under Section 389 of CrPC of an accused who has been convicted under Section 138 of the Negotiable Instruments Act, it is open to the appellate court to consider whether it is an exceptional case which warrants suspension of sentence without imposition of condition of depositing 20% of the amount of fine or compensation. The Supreme Court opined that when an accused has applied for suspension of sentence, the accused has applied for the grant of relief of suspension without imposition of any condition. Therefore, when the appellants have sought a blanket order, it is up to the court to decide whether this case falls under exceptional circumstances or not. the Supreme Court conclusively held that the trial court and the High Court have both proceeded on an erroneous premise that the imposition of condition of deposit of 20% amount is an absolute rule and does not accommodate any exception. Allowing the appeal, the Supreme Court directed the High Court to consider the case afresh.